Hi everyone. We'll get started. Thank you very much for joining our panel today. My name is Dr. Choi, and I'm a senior associate at Pillsbury Winthrop in our Los Angeles office, and I do mostly M&A transactions, and I'm really happy to be here with distinguished panelists to discuss this very interesting topic. So why don't we go down the table here and just give brief introductions before we kick off our presentation.
Great, thanks, John. My name is Julie Park. I'm a partner at our Pillsbury Winthrop Shaw Pittman's Silicon Valley office located in Palo Alto. My practice, I'm in the corporate and securities technology group, and my specialty is capital markets and securities law. So I represent companies going public and companies that are public in their 34 Act disclosure work, 33 Act work, including various types of financings they do as a public company.
Good morning. My name is Ryan Russell. I'm not currently practicing law. I'm a managing director at VA Asset Securities, it's Korea's largest investment bank. I am a New York and DC licensed attorney, however. I practiced previously in New York, Seoul, Singapore, and Tokyo on cross-border investments. Very nice to meet you.
Hello everyone, I'm Bobby Coupon. I work at Coupon here in Seoul. I'm chief counsel for the governance area, so I support them in their public company securities work, board governance, etc. I've been at Seoul for about 2 years. I moved from the U.S., Northwest Arkansas, Bentonville area, and I've been in-house for a while, just supporting companies with public company work, governance, everything else that they needed. Nice to meet you all, and I hope this is a good panel.
Good morning, everyone. My name is John Pandu. I'm a partner at the Korean law firm of Luchon LLC in the corporate and finance group. My work practice focuses on corporate and M&A matters, and I also work on diverse cross-border matters as well, including in the recent past acquisitions of the U.S. companies and other listings of Korean companies on the U.S. stock exchange.
Thanks, everyone. Ryan Russell will be moderating our panel today, so Ryan, why don't we get started?
Sounds good. And I know that panelists have plenty of interesting insights to share with us, so let's kick off. We will have some time at the end for Q&A, so if you have questions you'd like to bring up with the panelists, just say those till the end of the discussion if that works, and we can catch up on those later. So let's start off with, what does it take to prepare for going public in the States? There's a lot of prep that must go in advance. Julie, can you walk us through some of the key requirements, the key background preparations that are required?
Yeah, sure. So one of the key things that companies think of when they're thinking of going public is the accounting and financial areas. Hiring key personnel, including chief financial officer, and setting up an accounting team that has experience either with IPOs or public company accounting matters. That's one of the first things that companies think of. As you may know, in order for a company to do an IPO, they need at least 2, sometimes 3 years of audited financials. So that's one of the first things that companies start with. In addition, from a legal perspective, you need to start thinking about various legal diligence matters, including looking at your material contracts, looking at how your capitalization works, who are your investors, how that's going to work once your stock is listed public, whether they're all going to be converted, whether they're going to have voting rights. Also thinking about management and governance, including how your public company board is going to look like, who's going to be on your board, how many independent directors you're going to have, what kind of background are they going to have. and including, management members as well, your chief executive officer, CFO, and other management.
Great, thanks very much. Can we maybe back up on a bit of a higher level first? The United States obviously isn't the only target market for going public. JK, I think down the road is going to speak a bit about Korean companies' preferences and a little bit on the process of going public in Korea. But in addition to the United States, of course, there are other popular jurisdictions such as Hong Kong and Tokyo, Singapore, and regionally, and then London as well, of course. Why would a company choose to go public in the United States as opposed to another possible jurisdiction?
Yeah, that's a very important question. I think there's no question that the U.S. capital markets is the largest capital market in the world. It provides visibility in terms of the company going public. It provides access to capital, all these different types of investors from around the world. And also there are other advantages as well. For example, if you were to go public in the U.S. in terms of liquidity, thinking about long-term what the company wants to do, even when the company is considering various exit opportunities, either through acquisition or otherwise, the U.S. capital markets is definitely the place where they would have the most visibility, arguably the most efficient and easiest way to exit as well, because people are more familiar with the different types of requirements of the market.
Did you want to add something to that, or
The only other thing I could think to add, I think it's on the slide, is the equity, which is a really huge piece if you're concerned with hiring people based in the U.S. or just outside of your local region, because it's being able to offer equity that's listed on the U.S. stock. It's really liquid. It's a very attractive incentive for employees. So you can usually hire the best of the best. So that's really helpful depending on your industry. And again, being able to say you're listed in the U.S., it's sort of an easier starting point in certain transactions, whether it's M&A, because again, that equity that you can offer to employees, you can also offer it in an M&A transaction as compensation, as acquisition price if needed. And you can also, it's just helpful, right, if you're trying to get financing in the future. Like, look, I'm a U.S. listed company, these are my expectations versus, oh, I'm not. So, I'm starting on the back leg, on the back foot, that's also worth considering.
Yeah, totally agree with everything Bahi said. There's such a tough market out there for hiring talent these days that you want to be able to offer the best in terms of equity compensation, and that's what you're going to get if you're listed in the U.S. I would say, like in terms of acquisition and exit opportunities, I had one client recently that is actually a U.S. company listed on an Asian market that was looking at an opportunity to be acquired by a U.S. company, and they were facing some difficulty in terms of how that was going to work structure-wise, and even if they were able to overcome the legal structure, there was also some talk about whether their valuation being high enough, and if they were actually listed in the U.S., that they would be able to get a higher price.
Yeah, thanks very much. All right, so that's a good overview of some of the advantages of listing in the United States. Are there must be drawbacks as well?
Well, from my end, the biggest drawback is probably price. It's very expensive to list in the U.S. as opposed to some other countries. You can compare, and what we've done lots of comps, right, to see how it compares listing in the U.S. And the biggest fee in the U.S. is actually the underwriter's fee, right? They're generally beating the IPO encourage down to what time you should do it, when's the right time, are you ready to do it, are you not, is your due diligence appropriate? And I've looked at some numbers, and underwriters' fees are almost 75% of the entire fees. And of course, this changes based on the revenue, how much you're bringing in, and how much you expect the value of the deal going public. But you've got the underwriters' fees, you've got the accounting and legal fees, and those are getting ready, right? Because you've got to be ready for the SEC, you've got to have your GAAP information available and ready. But that's on the front end, just on the public. That doesn't even count the expenses of keeping up with the US regulations after you go public.
Exactly. So, once you become public, you have these continuing reporting obligations in the accounting, legal, the company in terms of, hiring and having retaining the right personnel who can do that. That's all costs that you need to consider as a public company. Also, when you're public, you are more visible to stockholders and investors. So you need to think about whether this is going to increase the chances of being sued by, certain interest holders.
Got it. JK, given your expertise, I'm wondering, could you jump in and maybe compare and contrast these points, both advantages and disadvantages of listing in the U.S. with what you see in Korea, and maybe have some of your Korean clients conceptualize the choice of jurisdictions listing?
Yeah, sure. I guess though my experience is, basically the same as already explained what you're doing, right? So, in general, Korean companies, it's only natural that they prefer listing on the Korean exchange rather than the foreign exchange. However, those that do list overseas tend to list in the US or UK stock exchanges. Those are foreign exchanges with relatively stable and developed markets, capital markets, and regulations. So the most recent examples includes, for instance, G Markets listing on Nasdaq, Hanator's GDR listing on the London Stock Exchange, and then the Coupons listing on Nasdaq. Those are all high-profile listings that Korean companies do overseas, but those are generally more the exception than the rule. What is the reasons for that? Maybe even though those are very developed jurisdictions with great access to capital, the fees are important as mentioned. And so it's my understanding as well that IPO fees are understood to be typically lower in Korea than other jurisdictions. Reporting shows that Korean IPOs pay fees of less than 1% of the proceeds to investment banks or brokerages. Fees as well tend to be relatively a bit lower. Legal counsel involvement in Korean IPOs may be somewhat limited compared to other jurisdictions. For example, in Korea, legal counsel does not generally take a lead role in preparing the prospectus or the securities report, which is as is in Korea, which I understand is a little bit different from the US.
Got it, thank you. So is it always an either or choice, or can one of you, is one of you able to talk about the possibility of dual listings? Is that a viable option in some cases?
Yeah, that's definitely a path that some companies do in terms of listing. So, for example, we have a client who's listed in the U.S. on Nasdaq, and they have a dual listing on the London AIM stock market. So that's definitely a path that companies that have a major market outside of the U.S. can consider doing.
Great. Julie, a second ago you were discussing some of the key preparations required for getting ready to go public in the United States. I wanted to touch back on that because I feel like we kind of glossed over it a bit. But also, JK, from a Korean company's perspective, are there specific preparation items that they
need to flip up its shares? So the existing shareholders of the private Korean company to be taken public in the U.S. Will need to flip up their shares.
Sorry, can I interrupt real quickly? What do you mean by flip up the shares?
Right, so in essence, they're exchanging their shares in the Korean company for shares in the U.S. company that will be taken public. This might be a company that has not yet been taken public. It might be a newly set up company in the U.S. which will later be taken public. But it may also be a SPAC, or a special purpose acquisition company, which is already listed, but through a business combination can be made so that it's combined with the Korean company to get that company actually, in essence, listed on the U.S. market. So what might happen is that the Korean company shareholders might transfer their shares to the SPAC, and the SPAC in return would issue new shares to the Korean company, to the Korean company's shareholders. There's various mid-level transactions that go to make that possible. That's one of the ways.
Got it, thank you. Bonnie, in your practice and your experience, what issues have you seen companies encounter as they go through the process of preparing to go public? Have there been times when, initially there was a plan to list publicly, and then as they went through the diligence process, something came up that just really made it not a feasible option? And what types of issues can derail a potential offer?
So, no need to clients, of course, but we've seen it all, right? There's the clients who start to do the due diligence, their own internal due diligence on as well, and realize, there's a problem with the books maybe, or the contracts, or something that brings eyebrows. And then it's getting the right legal and accounting team in place. They've got to have the right lawyers to shepherd them through the process, and a lot of companies might have at that point maybe just one or two lawyers, but really have to have a relationship with outside counsel to get through the process. Same with accounting, right? You have to have the right accountants there. You need someone who knows generally accepted accounting principles in preparation for SEC filings. And so finding those two people who can come in and manage it, and of course it's easier in the US if you're a foreign company, then you've got to get people on board in a separate location, right? Or if they're managing the part. And so managing a foreign company, sort of prepare them for a US listing. It's, there's cultural issues, there may be language issues, there's all sorts of things to consider. And then the reason people go public a lot, right, is because you get it, it's worth it. But the people who tell you it's worth it are the banks, the underwriters. So you have to have the right underwriters in place, holding hands with them through the entire process. And what happens is you might be pretty far along and ready to go, and the banks say, no, it's not right. The market's not right for you, or we've looked at the underlying, financials or whatever you have, and, behold. Or you have things like a pandemic, unexpected, that delayed many, many people, right? So you've got Instacart just went public, I think, last month, and they've been talking about going public for a long time. And you had to wait, you've got the pandemic, and then you have the global markets not doing so well, so you just got the timing right. And I know for the US, the market's sort of been soft for the last few years, and it's now starting to finally get back to the market getting better again. So there's things that are within your control and outside of your control, and it's managing those, managing your client's expectation of, this is going to happen or it's not going to happen. That we go as far back as WeWork, which was very, very close to going public 4 or 5 years ago, I think. And public information came out about the company, and they ended up having to pull back on that. So sometimes, if you're lucky, it's just like an accounting thing or a legal matter that you can fix or paper over, and sometimes it's just something that the public cannot see past, and you can't go public because it would just be a waste of your time and money and everyone else's. So there's risks on both sides. Is the reward worth it? For a lot of companies, they say yes, but there are companies that do it and then might decide it's not worth it, the risks, the ongoing compliance, and decide to, they decide to go private or they get acquired, etc., whichever way you go. So it's a tough decision, and you have to look at it and have all parties wanting to go the entire way, whatever you decide to do it.
Yeah, it sounds like based off of those cautionary tales you mentioned that, in the preparation process, once you flip that switch from internal due diligence to that external marketing and PR, by that point, you really need to have your ducks in a row.
Yes.
You need to make sure that any skeleton in your closet, at the very least, you're aware of it, so it's been factored into the cost benefit analysis.
Yes, you have to be prepared with your story and what you're going to say, and that's whether we're talking skeletons or not. In general, your story is a big story, right? When you're talking about the roadshow and going out and selling your company. So it's always easier if you're with people who've been at the company for a very long time, who can tell the story. It's a good story. There's sometimes stories that are easier to tell than others. But you have to say to people who are out there and they're just clamoring for your stock if you're lucky. And you just ought to be lucky.
Great. Okay, so realistically, as far as conceptualizing that process, and this is an open question to all of you, please either of you feel free to add your thoughts on this. I'm curious, how long should a company expect this process to take? From the second they sit down and say, hey, look, should we do this, to actually doing it? How much time is that going to take? What are the key bottlenecks? And what can we as lawyers do? What have you done to help shepherd that process along smoothly?
I would say if you haven't done any preparation in terms of preparing audited financial statements and anything like that, and if starting from the point where you're just starting to think about an IPO, I would say at least 2 years would be a minimum requirement. I think one of the key time-consuming items would be getting your audited financials prepared. So selecting an auditor, selecting a reputable auditor to audit your financial statements. That would take, months, if not longer. So that would be one of the key items to think about. As legal counsel, one of the things that you could do with a client that's potentially thinking about doing an IPO is basically getting them prepared, thinking about all these different things, what they need to think about, like who they need to hire, how they need to prepare their internal teams, their numbers, thinking about their contracts, counterparties to their contracts, diligence, their capitalization, investors, thinking about all those different things, I think would be one of the roles that legal counsel can play early on in the process, even if they haven't officially started the process.
In addition, you started, and I joined a company a while ago, many years ago, and they said, look, we're going public. Come in, help us get ready to go public. And it took almost 2 years before they actually did, and they've been doing this for a while. But it wasn't even just getting ready. It was like, okay, we think we're ready. Well, lawyers might not think you're ready, or your banks might not think you're ready. And then, the market is soft, now's not the time. So you've got entire people who are just sitting there. It's like they're sitting there waiting. Look, let's get some time to really get their ducks in a row. But I think the waiting sometimes is really hard for people, especially people who've been, with that equity, you want to be able to make it move for them. So that's definitely one of the toughest things, when everyone thinks you're ready and you're not, or at least you're ready. What's worse is if you think you're ready and everybody, you find out you're not, because there's a skeleton that comes out at the last minute. So, but yes, at a minimum, I think 2 years, just to be on the safe side. And if for some reason you get out faster than that, great. But if not, you can't be too surprised.
JP, just out of curiosity, what is the typical preparation period for listing in Korea?
That would be, I guess we also advise around like 2 years to be on the safe side, but even more aggressive or cases where there's even more preparation beforehand, it's a little less than that. So like 1.5 years to 2 years, that would be seen as like a more general period.
Great, thanks. Hey, why don't we move on and talk about some of the different structures, the possible types of listings that a company can do, and what factors should be taken into consideration when choosing how to do this. Julie, I know that you've done a lot of work with SPACs and other acronyms that I don't fully understand. Could you maybe explain some of those to us and what's popular, what are the reasons for that?
Yeah, of course. So initial public offerings, IPOs, are the structure that people are most familiar with. You're issuing additional shares through an underwriter, listing your shares on a public exchange. The structure, as many of you know, that became very popular in recent years was through SPAC mergers, so special purpose acquisition companies. So these are shell companies that are listed on a U.S. exchange, and the process is they would find a target company, an operating company that actually has a business, and they would, merge with this company, thereby creating a public company that's, listed on a U.S. exchange. There were multiple benefits of going through this process, and I won't go into too much detail on those. One of them was the ability to include projected financial information. Another one was a speed, cost factor, but as many of you know, this is not a desired approach anymore due to the SEC, strongly cracking down on some of the advantages that SPAC mergers had. So not a lot of SPAC activity going on these days in terms of SPAC IPOs and SPAC mergers. So it's become rather a rarity. It was really popular, I would say, between 2020 to 2021 was probably the peak. Another structure that is similar to a SPAC that we have used in the past is merging with a U.S. public company. There might be a already listed operating company that you could merge with. I've represented a client, an operating company that merged with an already listed public company that really had dwindling business on their end, and they were really closing down on a lot of its businesses, but they were able to go public by merging with that entity.
Bob, have you seen any other structures, any other thoughts on the structuring issue that you might want to mention?
The most popular one I've seen, of course, is generally just going and listing on, the NYSE or Nasdaq. Generally straightforward. But you do see those where it's a merger with a U.S. public company. And those are, I don't want to say it's slightly easier, right, what you said? It's a little easier. There's a company that's already there. You take it on, you merge with it, and then you become, there's various mechanics, but then you become a U.S. public company. But again, the direct listing is it's not the easiest, but it is the most straightforward. It's probably one of the more popular ways right now, because everything else you sort of have to explain yourself a little more unless it's a clear acquisition. In the end, you do what works for your client, right? It might also be dependent on what kind of industry you're in, what the CEO or founder, whatever, thinks that's the future of their company, because merging with another company might not be the way, because you might lose some of your equity or lose some of your control over your own company. So there's positives and negatives to both options, but everyone does what works for them in both ways.
Yeah, I would say though there is a bit of in terms of company image, SPAC mergers or other mergers with U.S. companies. The perception is that, if you have strong financials, if your company is doing well, you would probably want to go through the regular IPO process and not go through the other routes. That's the general perception, which is not necessarily true, but is that the stronger the company, you wouldn't go through alternative routes.
Thank you. Jacob, are there specific Korean law considerations that Korean companies or shareholders should pay attention to?
Right, thank you. So, I was thinking of commenting on this from a Korean legal perspective, since those are, those types of issues are we've assisted on in the past. So understand, from the way that the SPAC IPOs are a little bit out of fashion these days, but recently there has been quite a lot of activity. Most of that has been, I think, from more startup or venture type companies which do not have not for various reasons contemplated a direct listing, but have contemplated a SPAC listing. So just some comments on the pre-move considerations there. In preparation for those types of listings in the U.S., it's sometimes the case that there have been the shares in the Korean company have been made freely transferable, and there have been a lot of over-the-counter transactions. So there are a lot of shareholders in that company already. In that case, in the case of a flip-flop, those shareholders will be offered new shares in the U.S. company, and under Korean securities laws, delivery of the shares to 50+ persons are seen as an offer. So if the existing shareholders exceed that number, the contemplated receipt of the SPAC shares or the U.S. company shares will trigger a requirement under Korean laws to file a securities registration report with the Financial Services Commission. So this is both a regulatory hurdle and also a timing consideration that needs to be taken into account. There are also some tax considerations for the existing shareholders because due to the flip-up, they're disposing of their existing shares in the Korean company. They'll not receive immediate cash for their shares. They'll receive SPAC shares, for instance, as consideration, so they won't have cash at hand. But the flip-up may be seen as a taxable event due to their disposition of their shares in the private Korean company. So the possibility of tax deferral should also be looked at in advance. And if that's not possible, the shareholders should be aware that they may need to pay tax on the disposition of shares and should have the requisite cash at hand. One other quite important note is that Korea has a strict foreign exchange regulatory regime, unlike a lot of other jurisdictions. So this necessitates obtaining clearances from the Bank of Korea or foreign exchange banks in Korea with various types of foreign exchange transactions. This just doesn't include IPOs, but also just incorporating a company in Korea using funds from overseas, etc. So these clearances may need to be obtained with respect to various stages of the flip-up. For example, when the SPAC acquires the private Korean company shares, when the existing shareholders acquire the SPAC shares, the incorporation of any SPC, the special purpose company in Korea by the SPAC to facilitate the flip-up. This may occur, for example, in the case of a triangular share swap. So at various stages of the transactions, these foreign exchange regulations require clearances may be necessary, and they may hold up the transaction at various stages, so these will also be taken into account.
Great, thanks very much. Okay, New York Stock Exchange or Nasdaq? Doesn't matter? Why?
That's a question that I get frequently. The short answer is it doesn't really make a difference. I think both exchanges have made many changes in the past years, and I personally don't see a huge difference in listing in those two markets. They both try to be pretty company friendly and have similar requirements in terms of reporting requirements. They provide similar services for listed companies like the investor websites, hotlines for reporting ethics violations. So really not much of a difference. As you may know, NYSE has been traditionally the favored market to list on for more traditional companies, and Nasdaq has been more for technology-focused, newer companies. However, I would say that is not really a rule in these days. There are a lot of tech companies that are listed in NYSE and also the other way around. So I would say in reality, there's really not much of a difference.
The only other thing I would add is, and this might have changed, but the NASDAQ is slightly less expensive to list on than the NYSE, so that, if someone's counting the pennies, that might be a reason to do that. But otherwise, in the end, it's all the same. You're a U.S. listed company, your SEC regulations will roll down and you'll have to, Nasdaq and NYSE are pretty similar in how you'll be governing your company. So in the end, it's just a personal choice.
Great. Now you have the floor, let's keep you talking. We've been asking JK a lot of questions about comparative legal issues with respect to cross-border access to capital markets, but you also have, especially recently, some very interesting experience in that forum. What would you say are some challenges that you've seen from non-U.S. companies looking to access, looking to go public in the States?
Just starting with getting the right support, right? The right legal and accounting support, internal accounting as well as your external auditors. You're convincing them, or you're say when I talk about external auditors, you're not using, say, KPMG US, you're using KPMG's, say, Korean affiliates, right? And so what is your service like here versus in the US? And I'm sure it's perfectly fine. But those are things to consider, right? So you've got to get your ducks in a row in your local country. And then you have to decide where to list, right? Not where you list, but things like headquarters. And are you a Delaware company, or are you a, Korean company in terms of what your governing rules are? But you're going to list abroad, right? So a lot of companies will be Delaware companies or whatever, California or New York companies and list, and that's the easy part. But you might be where you are and decide that's what you're doing, and so you have to take that into consideration. There's always the language challenges, right? You could be an English-speaking country, which does make it a little easier, but there are plenty of foreign countries, foreign language companies that list in the U.S., and it's not that much harder, right? You follow the rules, and you're writing things sometimes in two languages, right? There are certain things we do at my company right now where you draft them in English and then it has to be translated into Korean, so it's available, especially for governance documents, because it has to be available to the entire company, not just one side of the company. So, the language and translation services is actually kind of a big deal, especially for foreign country companies, and that could add up. But it's also in terms of, again, language is a good one. Your employees, right? You might have foreign, and by foreign I mean U.S. employees working in your local company, and how are they working, and in terms of accounting, right? You need to make sure you're explaining your accounting rules from the U.S. perspective appropriately, so you know to support the results you're getting from your local sort of business partners or what you need. Because if you miss something in the nuance, especially in accounting, that can be a really big issue that translates into millions or more dollars. So language is it, location is a big one, right? Are you going to have headquarters in a foreign country, in the US, where are you going to be based? How do you deal with regulators in both countries? Because, there's many big things, but that's another big one, because you've got to obey, you've got your US laws you're dealing with in governments, but if you are based in a foreign country, you also have to deal with all those regulators and those laws. So you've got twice the sort of issues to deal with there, things to manage, which in some cases might mean even more employees than you would if you were just, say, a Korean company just listed in the US. So you have to decide if that's worth it for what you get out of it.
Great, thank you. JK and/or Julie, any other thoughts on specific challenges that might apply to non-U.S. companies, either on the operational side, compliance issues, or any other issues?
One thing that came to mind while you were speaking was in terms of management. As a U.S. listed company, since the CEO and the CFO are often the people that are the face of the company, and you need to give your investors, stockholders, updates in terms of how the company is doing from time to time. So I know that I mentioned hiring key personnel is one of the most important things that companies start with, but I thought that would be important especially for a non-US company, because you want someone who probably understands your business and main markets that you operate in, but at the same time, who is able to communicate to your stockholder base. And if that is the U.S., public company market, then you would need someone who is completely fluent and is comfortable speaking with investors in the U.S.
I agree, that the language issue is quite important. In our cases where we've seen Korean companies contemplate this in the U.S., they already have, either the founder or certain members of the company already have experience in the U.S., or the getting members who have, quite a extensive experience in the U.S. to facilitate that. It's not directly related to the topic, but the language barrier itself in Korea, the Korea Stock Exchange, it's also possible for foreign companies to list on the Korea Stock Exchange. And in recognition of that and of the language barrier making things easier, the Korean Stock Exchange is also trying to remove language barriers by making more English documents available. So that's one trend that seems popped into my mind as well.
Very interesting. One last thing that I'd like to add on the slide is I see a lot of Korean companies, especially large conglomerates. One of the main considerations is, control of the company, whether they can retain control of the company even after the company is listed in the U.S. And one structure that you may consider that was, basically started in Silicon Valley, where I'm at, is you can create different types of common stock or other stock that has different voting rights. So you could opt to list common stock that doesn't have voting rights and keep the voting rights concentrated in a certain stockholder base.
Great, thank you. All right, for the time we have remaining, I don't think there's much left before we open up for any questions. Let's see if we can touch on a higher level the broader trends we see in IPOs and capital markets and where things have gone recently, where they might be going. How have technological advances changed and affected the IPO process up to date? And specifically artificial intelligence, has it been a force of change, and do you expect it will be in the years ahead?
I think definitely, especially where I'm located in the Valley, people are starting to use AI, generative AI, in terms of drafting and other things. I would say lawyers are a little bit more conservative in terms of relying on those technologies, but definitely our clients who are more adventurous, I would say. In reality, I think it is taking some time. The change has not been very quick. I think people are testing things and trying out new things, but it hasn't made a drastic change in terms of the IPO process.
I will jump to the electronic file editing process, because if anyone here is old enough to remember, there were times we would spend late nights at the printers, printing out pages, reading them line by line, editing them, and getting them back to, there were many nights spent at the printers for anyone who's ever done securities type work. And that's just not done as much anymore, right? Right now, everything's electronic. You get it by email, you make changes, you send it back by email, filing is all by email.
But those changes, those have been around for a long time.
They have. That's not AI. But I do remember the time spent at the printers, so that's just more one of those technological things. I mean, you do lose something in terms of the camaraderie and the late night. You really formed those.
You was late nights at the printer?
Not necessarily, but there were really good client development, moments. You really got to know your clients. You're sitting there and reading them. Now, some might say you maybe had more time and you were more focused and you really go in line by line, whereas if nowadays you might be anywhere, you might be sitting at home because it's midnight and you're waiting for the printing document to come out. and looking at it one last time and catching those changes. I don't know that anyone's searched to see if whether that's good or bad, but things like that, and that's not specific just to IPOs, that's general law and everything else, right? More things have been taken online and are not offline as much, and you can do them from wherever your computer is. But that does have the advantages of giving you more flexibility, and you're not sitting there and rush like you've got to be done like this amount of time, or else this is not going to happen. So that's just it's a model surveillance thing. You don't have people sitting there waiting and they're building time, etc.
And it seems only natural that those types of changes, which, in retrospect, seem so natural and almost organic. It seems that those similar types of, seemingly minute alterations that accumulated really change industry practice. There must be many more of those coming down the road. Is it too soon to guess what they might be, how things might change, or is there anything that we can peer in the future and kind of provide predictions on? JK, Julie, anybody, any thoughts on specific prophecies, or is it really too difficult to talk?
No prophecies here. I would say, though, that I did speak with, before this conference, people who are leading up the charge in terms of these changes at printers in the U.S., including DFIN, Merrill, but they're, so quite surprisingly, I do think they noted that they are working on some changes, but nothing immediate that they see. I'm sure, generative AI will play a role in terms of drafting and things like that.
And just quick, that does, of course, make it easier, right, to list from wherever you are around the world. You don't have to worry about physically being in the U.S. or anything, maybe roadshow, that's it. Especially post-COVID, right, everything is done online on Zoom. So now you don't have to be at the printer, you don't have to be at the lawyer's office ever, same with the banks, you can do it all online, most of it online, and I think that makes it easier from wherever you are.
Definitely, yeah. COVID has accelerated the changes. I would say even before COVID, a lot of my colleagues were doing printer markups, in person and giving, scanning those and sending those to the printer. It's really rare these days, and everyone's doing electronic markups, and associates don't know that written hand markups are possible.
Great segue bringing up COVID. It's almost as if you knew where we were going with the next slide. How has the IPO world changed through and from after the pandemic? Did COVID kill IPOs? Has it changed IPOs in any meaningful way? How are things different? How are things the same? Any thoughts?
Yeah, I think Bonnie touched upon it recently, and I would say maybe less COVID. As many of you know, during COVID, we had a very hot capital markets. 2020, 2021 was great. There were a ton of companies being listed, a ton of financing that was being done, biotech companies being listed. More recently, the last couple of years have been slower in the capital markets, but we, as Bonnie mentioned, we are seeing positive signs of improvement, and it's also been a great time for some of our clients to get started on preparing for IPOs. As we mentioned earlier, it takes at least 2 years from when you start thinking about an IPO. So this is a great time to get started on preparing internally your audited financial statements and other things for your IPO.
It's almost like COVID didn't have an immediate impact, and the market was just doing great for a while. COVID or no COVID, companies were going public, and then all of a sudden, as COVID almost started to wane, the global markets also sort of fell into disarray, and so maybe that was an indirect effect of COVID, and that then seemed to steamroll and delay a bunch of IPOs until very recently when things are on the upswing. So that's just a guess on my part. I haven't looked into it, but it didn't have an immediate effect. I was surprised that how many companies were continuing to go public even in the middle of COVID.
really appreciate all of your thoughts. But unless there are any other points that the three of you would like to make at this point, perhaps we can take a few minutes and see if there are questions or comments from the audience.
I don't get like I'm loud.
All right, great.
Is there, it's all new to me, so I'm having trouble kind of understanding the legal advantage of going public. Is like there a point where a business cannot grow past a certain point unless they do go public? Because it seems like a lot of scrutiny.
Yeah, you're definitely right there. And that's one of the considerations that, companies take when making that determination. I would say one of this ties into the employee compensation part, hiring talent, and employees often want to work at a company where they can make, they can be owners of the company by getting equity compensation and being at a company where that equity is liquid and they can sell it. So that's one of the considerations. I would say it's probably easier if the company were to try to obtain financing once you're a public company. A big reason why a lot of biotech companies that have zero revenue right now are listed publicly is they make all the information about what their company is doing, what their business is, public, and they use that, they continue to report on the progress of whatever, drug or whatever they're developing public, and they use that to obtain financing from the public markets. So that's a consideration. So it just depends on the structure of the company and what you're looking to do long term, I would say.
If helpful to explain it, it's, you might reach a point where it might be hard to go and want money, but if you go public and you sell shares of yourself, people buy it. That's you publicly paying for it. And so you have a huge influx of cash that you can then use. You have all the scrutiny and regulations on how you can use it, and you have to disclose a lot of it, but you have access to a sort of whole new funding source, which, in order to be public, you should be able to get money from banks in general. But that is just like another avenue for revenue, basically.
So it seems that there definitely are advantages, but these might not speak to many companies, right? It's not better for every company to go public, obviously.
No, definitely true. There is increased scrutiny, increased risk of litigation. One issue that I mentioned earlier, the control issue. Some companies, they want to make sure that the largest stockholder remains in control of the company, so that's part of the reason why you may not want to do a public offering and be a public company. There are various requirements that you need to keep with, including having the board be majority independent, all of your committees, including your audit committee, compensation committee consisting of independent directors, and that may not be something that your company is willing to do.
And just to add some points from a Korean legal perspective, all of what my said are true, and it's the ambitions of the company and the cash needs of the company. If the company is doing well or has big expectations, quickly outstrip the current revenue of the company. In that case, it's usually typical for the company to get some financial investors into the company. Those financial investors will always think of their exit from the company. And in Korea, what's typical is that in those financial investors' investment agreements, there's an IPO clause where the company uses covenants to make its best efforts to IPO in the near future. And those types of legal obligations as well propel the company to an IPO once it reaches a certain stage. So that's something that's also taken into consideration.
James Shaw from Logan. In the last 6 quarters, because of rising U.S. interest rate, we've seen a lot of IPO activities, but because last number of SPACs, there were a lot of SPAC transactions. If you represent the target to be merged to SPAC for IPO, do you view that if the sponsor has a lot of warrants in the SPAC, do you view that negatively? And do you try to negotiate down the warrant by the sponsor? And also the SEC's rule to expense the warrant, does that have any change on the landscape of the structure of the SPACs?
Your question was, if I'm rephrasing it correctly, if the sponsor has warrants in the SPAC, in the process of negotiating the merger with the target, does that provide some sort of leverage in terms of negotiation?
Generally, do you view the warrant as a disadvantage for the target, because the warrant gives the sponsor a lot of free ride?
Yeah, that's right. So I would say that it's regarded as a disadvantage because I think it's very common. So financially speaking, I mean, I'm not a banker, so the analysis should be done by the bankers, but I think in terms of the SPAC structure, the warrants are so common that I think it's rare that that would create a barrier in terms of adding something that, in terms of creating an issue for the transaction to actually happen.
Question on auditing. I'm okay, I can keep laughing. Come on. So you mentioned, part of the time getting set up is selecting an auditor. Presumably, a lot of these private companies are going to have an auditor for their investors. Is it recommended that you hire a different auditor for the IPO?
Not necessarily, right? Your ongoing relationship counts for a lot, but sometimes some bankers do want to see what's one of the big four, the big six. I've lost track of how many there are now, right? Having those is sometimes very helpful, especially if they're going to be, they've got the experience in the background. But there are many companies who go public with their smaller, less name brand, but long-term relationship auditors who do have the background and can make sure their books are good for non-GAAP, or if for some reason they're GAAP, great. But just as long as they can do the work and make sure your financials are GAAP ready, in the end, that's what you need, right?
Yeah, one other thing would be that your private company auditor may not be willing to audit you as a public company. There are, as you know, smaller audit firms who don't function as a public company auditor, so that is a consideration. I would say that the majority of my clients, when going through IPOs, would hire a new auditor for multiple reasons.
I think we have a question here in the middle, in the back.
Yeah, I can just be loud. Aaron Nyquist from Frederickson Environment, Minneapolis. Obviously, like in the U.S., every 4 years, there's, depending on change of administration, the SEC scrutiny kind of swings from one end to the other, and it feels like that gap has been widening in the past, 10 to 15 years. Does that kind of pendulum swing, have you perceived that having an effect on, like, foreign companies choosing to list in the U.S. versus going to London or Hong Kong or another exchange?
Good question. I have not heard of any companies resisting to list in the U.S. or deciding to list in a different market because of increased requirements in the U.S. I think that, may be something that companies consider, but big picture is probably less important, is what I would think. the European markets, other, Asian markets, I know there are big markets, but European markets, from my understanding, is that it's a very complex listing market of 35 different markets. It's not as big as the US. So if it's for a company that has a significant, operation in a certain different country, maybe, but I think overall, in terms of a company that's considering going public in the US, not a huge factor.
Just a quick add, what I've seen from the SEC side is, despite the change in administration, you never get where there's less regulations. No, unfortunately, no one's ever removing regulations or making it easier. It doesn't matter who's in, there is always more. So, right, it keeps us busy, but it's never more. So I think any company going into it just can look at the history and go, it's not going to get easier. It only gets more and more complex. And just add that into what they weigh as they make these decisions.
Jake, I do wonder, given your years of practice here in Korea, have you seen fluctuations in Korean companies' interest in listing in the United States based off of relatively short-term or mid-term changes in regulatory strictness levels?
I wouldn't say so. Of course, the sample size is quite small. As I mentioned before, Korean companies tend to list Korea, not overseas, but I don't think it's the fluctuations are due to regulatory strictness. I think it's more, the successfulness of the IPO, the most recent IPO. For instance, Coupon's IPO was, a success, which brought a lot of interest. But then there was, subsequent decrease in the stock price, which also decreased the interest level somewhat. So I think it's more of, the return on what the IPO will bring to you rather than the regulatory requirements.
Great, thank you. I think we might have time for maybe one or two more questions if there are others. Otherwise, we are happy to end now and allow everyone to have an extra cup of coffee. Coffee time it is. Thank you for your time. It was a pleasure having you with us.